Good afternoon and welcome to this special edition of Fourth and State, a video service of the Milwaukee Journal-Sentinel Editorial Board. Hello, I'm David Haynes. I'm the opinions editor of the Journal-Sentinel, and we're joined today by Susan Happ, the Democratic candidate for State Attorney General. We'll meet with Happ's opponent, Republican Brad Schimel, at 11 a.m. on Thursday. Now at 12:30 tomorrow, Governor Scott Walker will be here at Fourth and State, followed by Mary Burke, his Democratic challenger, at 10:15 on Wednesday. All of these interviews will be streamed live right here at JSOnline. So what are we doing here? Well, each year during election season, the editorial board invites candidates to sit down with us and discuss the issues. That's exactly what we're going to do this afternoon. And then we'll write a series of editorials based on these interviews and other research that we do. We will not make endorsements in these races. We're also joined today by members of the Journal-Sentinel's news staff. We operate independently of one another, and the news side and our editorial board are separate staffs. Now let's meet Susan Happ. Susan is District Attorney of Jefferson County. She was first elected in 2008 and re-elected in 2012. She's a native of Jefferson, Wisconsin, and a graduate of the University of Wisconsin-Madison and the UW Law School. She was an attorney in private practice prior to becoming DA. Susan Happ, welcome to Fourth and State.
Thanks for having me.
You're welcome. I'd like to start with a question on open government. The Attorney General in the state has some influence over how those laws are enforced. I wonder what specific things you could commit to doing today that would help to fully enforce the state's open meetings and open records laws.
Well, you know, Wisconsin has a strong tradition of open government. We have some of the best laws, quite frankly, on the books. And I have a journalism degree as well, so I understand, you know, the need for not just the press, but the public, right, you know, to have access to their elected officials and to have confidence that their elected officials are acting in an appropriate fashion, an open fashion. We have good laws on the books, and I think you know, something I'd like to talk to local law enforcement and local DAs about is, you know, where can DOJ assist? As you likely know, most of our open meetings or open records complaints come first to the local elected district attorneys, and they're often complicated with a lot of nuances to the cases themselves. And so sometimes, you know, local law enforcement, local district attorneys have said they just don't feel as equipped or experienced to deal with those types of violations. But I think they really do need to start, you know, first and foremost with local prosecutors, but also, you know, let them know that DOJ can be a good resource for those types of violations. The DOJ does do a good job currently about putting out information and materials that are available to district attorneys such as myself to investigate and to ultimately prosecute those types of violations. But I think we can do more to help particularly smaller communities and counties who maybe just don't have the resources or the experience to, you know, to handle those types of complaints. So,
is it a case of education, or is it are there other things that you can envision?
I think it's both. I think it is education because there aren't a lot of these types of complaints that are made, but when they are made, they are inevitably complicated. Oftentimes, you know, you're dealing with city council meetings or other meetings where you have different people on different sides of an issue who are sort of pitted against one another. So they can be a little bit, you know, politically charged, if you will. And so sometimes it's nice to be able to have, you know, DOJ as a resource to run those types of situations past and to seek that advice.
Do you think there's been any backsliding on that issue in the last few years?
Well, I know that there has been criticism, you know, as we went through this primary, quite frankly, about the current Department of Justice's inability or failure, as they've said in the press, you know, to have any sort of open records or open meetings filings. But I think to be fair, you'd have to look at first, you know, what types of referrals had been made or what types of violations had been alleged to fairly say whether there should be an increase in those types of prosecutions by DOJ.
I want to jump in with a question about sort of the role of the AG. You and your opponent, just last night, I guess, in the debate, have a disagreement about whether the AG should defend all of the state's laws. He essentially has said yes, with possibly one exception. And you said there are exceptions, and the voter ID law and the gay marriage law were two that exceptions you would have made. But I guess I'm wondering, from the point of view of the whole state, why is it that you get to pick which laws to enforce and which laws not to enforce, and doesn't that politicize the office?
I'm glad you asked that. It has the potential to look that way if you verse it in terms of picking and choosing which laws to enforce, because you can't do that. That would be inappropriate. The two examples that you gave, and I think the easiest one to talk about, quite frankly, is the ban against same-sex marriage. So you have a law that's on the books here in Wisconsin. The voters had voted to amend our Constitution, the Wisconsin Constitution, to define marriage as between a woman and a man. And then there were challenges. And part of the problem with that was that it still is violative of the United States Constitution, our Equal Protection Clause, that says we don't get to discriminate against people based on sex, race, age, creed, or sexual orientation. And so part of the issue with that law and why I did take the stand that I took wasn't about picking or choosing. It was about saying, look, we've got a very clear law, but unfortunately it contradicts and is, in my opinion, was blatantly unconstitutional. And at that point, the Constitution trumps. And look, you know, with same-sex marriage, if we'd have put the issue to voters back in the 50s and 60s, for example, talking about segregation, probably the voters would have overwhelmingly approved that type of a law. Doesn't make it constitutional. And so it's really not about picking and choosing. It's about having the courage, having the independence to say, look, there's this law that's been passed, it's violative of the Constitution, and I'm not going to defend it. And you know, I'm not the exception here. The past three attorneys general, both Republican and Democrat, have declined to defend laws when they are blatantly constitutional, including the current attorney general. And that was regarding the domestic partnership registry. And you talked about my opponent. He originally said that he would not have defended our domestic partnership registry. He changed his mind and said he would defend it. And even last night, when he did say that he would defend every single law, he was asked if he would defend the law that related to outside groups coordinating on campaigns, and he said he didn't know. And so with me, you know, what I try to emphasize is I will talk straight. You will always know where I stand. And so these, you know, areas where I've said that I have grave concerns about the constitutionality of a statute, I've had the courage and the independence to say exactly what I think the problem is, but it's not based on any political ideology. It's based on a strict interpretation of the Constitution.
But with the voter ID law, that law's been, there's a very similar law that the U.S. Supreme Court upheld from Indiana. So how could you make that claim on that particular issue?
And you know, admittedly, the voter ID law is a trickier issue because we have seen developments as our law has progressed, as the challenge to our law has progressed. My biggest concern, and I'm glad that the Supreme Court did you know, put it on hold now for this election, was the timing. The timing of the implementation so close to the election. And I had a gentleman the other day who was an attorney, fortunately, said his 93-year-old father had his ballot returned, his absentee ballot, didn't know what to do with it. And there were instructions, but it's admittedly confusing. So fortunately, he had someone to go to say, you know, what do I do with this now? But back to your question about the constitutionality of the law. We've seen that even among the Seventh Circuit, the judges are absolutely equally divided. 5 say it's constitutional, 5 say it's unconstitutional, and realistically, it is going to make its way through the court system, and likely the United States Supreme Court is going to rule. My concern with the Wisconsin law is this. We have 3 express requirements for voters to be able to vote in Wisconsin. This creates a 4th that's not in our Constitution. So again, it's not about ideology, it's not about politics, it's about just making sure that everyone who wants to vote, who is eligible to vote, can do so. And you know, I've prosecuted election fraud, and the cases I've prosecuted were not cases of voter impersonation fraud. They're folks who voted twice, they're folks who are on probation for a felony and they couldn't vote. And so, you know, I think that's the biggest concern, you know, that I voiced about our voter ID law.
Ernie, I'm sorry, I stepped
You
in.
know, is there a distinction between a constitutional amendment passed by the voters and a bill passed by the legislature, though? That's what the Walker administration and Attorney General Van Hollen have argued.
And I know they have, and from my perspective, no, because you still have to comport with the United States Constitution on the Equal Protection Clause there. And as I alluded to earlier, you know, if you had a law that was put to the voters that was blatantly unconstitutional, like approving of segregation or maybe banning interracial marriage. I mean, we have to be able to say, look, even though the voters approved of something, we've still got to be able to make sure it comports with the United States Constitution. So I think that's an important distinction.
You said this isn't about ideology or politics. Do you mind stating your position on voter ID and same-sex marriage? Where do you stand on those two issues?
Well, from the very beginning, I've been very clear in terms of my, if you're asking my personal opinion. The same-sex marriage is clear. That's about people being treated equally. And so I do believe that people should be able to marry who they love. In terms of the constitutionality of it, that is the crux in terms of an attorney general candidate.
I understand your position on the Constitution. I just want to know your personal position on both.
Yeah, and in terms of the voter ID, as I've said, I want to make sure that every eligible voter is able to vote, regardless of what party they belong to. I mean, that is a fundamental, constitutional right. And so, as I've said, that is a concern that I have with regard to our law, is that it creates a fourth requirement that's not in our Constitution. But in terms of my personal belief, I think that our law is flawed because it does create that additional requirement that puts an onus on people that's not in our Constitution.
So is it just a coincidence that those two issues are the ones where you said you wouldn't represent the state?
Yeah, I mean, I think it is because there are laws that I don't agree with. For example, our eminent domain laws are fairly aggressive. I don't agree with some of those laws in terms of how they are applied, but it's something that as Attorney General I absolutely would enforce.
Would you have handled the abortion law that's currently the one that restricted the admitting privileges? Would you have taken that? Would you have represented the state on that?
That case is another tough case, Dan, because we look at the restrictions that it puts on women in order to be able to access health care. And, as the judge in that case noted, the proponents of that bill were unable to articulate any reasonable basis or singling out a single medical procedure. On that one, I would want to take a really hard look at what the legal arguments were made, what the constitutional challenges were, to be quite frank, because that one, I definitely need to know a little bit more on that one. Personally, I have concerns about restricting women's ability to access health care.
This would be a third case that would be...
Potentially. Mm-hmm.
And again, another coincidence.
Well, on that one, I've said that I would want to take a harder look at it. But that's when, again, and that's why I'm saying I would want to look specifically at the arguments that were made and to look at the rulings and to look at what the constitutional challenges were specifically.
If we could talk about the Reynolds case,
Mm-hmm.
Little news on that today. It was thrown out by the Office of Lawyer Regulation. But in your mind, is this settled at this point? Mr. Schimmel has said flat out, you've lied about the facts in this case. These facts have been known for some time, and yet at the debate last night, yesterday afternoon, it looked as if you did get some of the dates wrong.
Right. Sure.
What happened there?
Well, with regard to your first part of the
Yes.
question, with the Office of Lawyer Regulation dismissing the complaint, I'm obviously pleased. It's what I expected because I appropriately had no involvement in that case. I screened myself off as soon as I saw the name, and it was assigned to another assistant district attorney in the office, which is what our ethical rules require, which I believe is why the Office of Lawyer Regulation did in fact dismiss that complaint. And part of my speaking about the dates is precisely because I wasn't involved in that case. It wasn't any sort of intentional statement. When I looked back at the case, I'm thinking 2014, and I misspoke when I said that it had been referred in 2013. It was resolved in 2013. And so the point of all of this, though, is that I handled that case in terms of when it came in, screening myself off in the exact way that the ethical rules require. And it isn't different. I respectfully disagree with Brad Schimmel that it's any different than his office continuing to prosecute the Bill Kramer case, which is another sexual assault case involving a Republican who's donated to Mr. Schimmel's campaign. He screened himself off. I think that was appropriate. And so, I haven't sought to make this any sort of gotcha moment or to seek any sort of advantage on that to say, oh, look, he's done something wrong, because that's what our ethical rules require. Because when you work in communities like we do, you are often going to have, some knowledge of a person, whether they go to your church or they've grown up in the community with you, or someone knows a family member. And so it's inherent on district attorneys to know when it is that we refer cases out and when we keep them. And I've done that several times where I've referred cases out for special prosecution. Brad Schimmel's sent more than a dozen cases over to my office for special prosecution. And so I think we both know when it's required for us to have a special prosecutor.
But in the end, in this case, he was treated pretty leniently, because after a year, the charges against him were
Lee,
reduced.
a little bit of context for our viewers about Reynolds and the case.
In what way?
Just this was an individual that you had a business interest, and your husband had a business interest with at one point, and then he was
Land contract that
Yeah.
you had with, you and your husband had
Just for those who haven't followed.
with Mr. Reynolds, and during, and you had a land contract with him, and the contract, I believe, was between 2009 and 2012. Previous to that, there had been some allegations of sexual misconduct by Mr. Reynolds. The case came to your, to you in 2012, I believe. So that's the background
Yeah,
to this
okay.
case.
Sorry.
And just one detail, you said the case was resolved in 2013. I don't think it was resolved until this year, right? The deferred prosecution agreement's from March.
Right, 2013 was when the case was actually charged out.
Right, it was charged
And then
out
there was a deferred prosecution agreement, thank you, that was approved by a judge this year.
I guess the remaining question I had is that, in the end, many people believe that he got off pretty well on this. And are you pleased, even though you weren't directly involved in this case, had no involvement at all, are you pleased with the outcome of this case and how it was handled in terms of the penalty that he received?
And I can't speak to that, first of all, because it's not closed, it's open. That's what a deferred prosecution agreement is. So someone stays open on a bond with the charges still pending, sort of in limbo a little bit. So that if someone is removed from their diversion agreement, for example, they can be, the case starts up again. And so I have to be careful. But the reality is I don't have the facts of the case because I screened myself off. That's why the dates do get difficult for me, because this is a case where I was not involved. And so I don't know all of the complexities that went into the case, other than literally what I've read in the press and what has been spoken about publicly. And so this is a case, like many, I can talk in generalities, when you have delayed reporting, of a sex crime, and I think these allegations were from a number of years prior, it becomes complicated. And there were familial complexities in terms of, the victim and a divorce and things of that nature. And so I can't speak to why the case evolved the way it did. What I can say is this, is that there was oversight because the court approved of this, agreement, and so that's something where, I can't speak to all the specifics simply because I was not involved, and so I think it's really hard, and I think the campaigns and the parties could go back and forth frequently and try to take cases, piece by piece, and perhaps out of context, and I think that would be a disservice both to Brad Schimmel and myself, but also to the voters, because we've both been practicing a really long time. And so you can't just take a case and say, well, it was a sexual assault case and now it's potentially, resolved in a certain fashion. I think that's unfair to do that.
Given how direct the relationship with the defendant was in this case and the amount of money, the large amount of money involved, I'm curious as to what standard you would set up going forward if you were Attorney General for recusing the office and getting a special prosecutor involved.
Well, you have to look at the ethical rules. You have to look at the fact that when there's a conflict or an appearance of a conflict, the obligation of the prosecutor is to screen himself off or herself off. And so for me, when it came in, the land contract had been signed, in 2009. In my mind, it was a done deal, so to speak, in the sense that as long as Mr. Reynolds made his payments, the property was his. And so all I can say is that I would never, ever compromise the integrity of a case, compromise the confidence, that a victim or that the public has in my ability to handle it. And so in that type of case, especially in light of what I think have been some misrepresentations and misunderstandings in the media about this case, perhaps I would look forward at being, I guess, hypersensitive and hypercritical. That even though the ethical rules would not require that, that I'd be sensitive to that. But I think that's unfortunate. Because in this case, when I look at this case, I know that I had no involvement, and so now what we're talking about is, this appearance after the fact in the case that I never handled. So I think it's unfortunate.
You mentioned misrepresentations in this matter, yet we didn't hear from you during the entire controversy. Yesterday was the first time I heard you discuss it. Why didn't you? And we talked about openness earlier. You haven't talked very much about this case in the past. Why didn't you come forward, explain what you knew about the case?
Right.
And, I mean, even after the complaint was filed against you with the Office of Lawyer Regulation, you could have stated, you said now that it's obvious that it was going to be dismissed. You could have told us that at the time, but instead it was your campaign spokesman who was responding on your behalf throughout this period. Why
What
is that?
was obvious that it was going to be dismissed?
You said that the complaint, when he said that the Office of Lawyer Regulation complaint was dismissed, you said you had expected that from the beginning. Sure. You could have made that clear early on instead of letting
Well,
this
you have
play
to be very careful, because even though this was something brought to the media's attention even before the complaint was filed with the Office of Lawyer Regulation, I know the victim made public the form that she had planned to file. She's still a victim. It's still an open case. And so quite frankly, I didn't expect to need to have to address it. And then once the complaint was filed, again, those complaints are confidential, even though it had been brought to the public forefront by the victim. And so I was trying to respect the victim's privacy, quite frankly, and the fact that the case was still pending and still open, because to the extent I'm going to talk about the specific facts of the complaint or the allegations, the last thing I would ever want to do is have a victim who now feels that she's not being supported by our office. So that was really the primary reason, was we didn't expect people to still be talking about it, quite frankly, because from our perspective, from my perspective, I did what was required. I followed the rules. And, that was the end of the story as far as I was concerned.
And could you just clarify what you did with your victim coordinator? The victim claims that she was told not to go to the media or to talk to the media about this matter. Is that something that you encouraged through the victim coordinator for Jefferson County for her not to do?
I was not involved in the case, as I've said, so I would have had no direct discussions with my victim witness coordinator. I did say last night, because my opponent was trying to say that my victim witness coordinator somehow contacted this woman and told her not to speak to the press, that our office always, and I've been in many conference rooms with my victim witness coordinator, having conversations with victims where there is going to be media attention. And the conversation that I've heard her have in every single case has been, you may be contacted by the press. You're under no legal obligation to speak with them, but you may. And I have no reason to believe that was anything different.
Let's touch on something a little less controversial, the John Doe investigation. The ties between outside groups and Governor Walker's campaign. Would you have assisted John Chisholm and the other prosecutors in that? And do you think the law needs some changing? Does the process need to change somehow?
Yeah, I would have assisted in that, and here's why. I think when we talk about elected officials, we have to not only have the appearance of not being biased, but the ability to actually act in an unbiased fashion. So, as district attorney and as attorney general, certainly anyone who betrays the public trust should be prosecuted, should be investigated, and that is whether they're Democrat or whether they're Republican. And I think the unfortunate part of what we've seen with these John Does now has been a lack of trust by the public. We've got to work to restore trust in our elected officials. The problem, of course, now that we have the pitting of the various political parties in the interjections, you have the current Attorney General saying, I wouldn't have assisted because, look, this is the governor and he's a Republican. Well, John Chisholm's a Democrat as well. Now, would my involvement in that have anything to do with the fact that John Chisholm's a Democrat, that the governor's a Republican? No. But again, we're talking about perception. We're talking about people having faith and confidence, in the investigation and the integrity of our system. And so to that extent, that might be somewhere where you have to be cognizant of that in terms of how you go forward on something of that magnitude. Because I think, the real issue has been just how complicated this case has been, even though the jurisdiction, was properly in Milwaukee County.
Would you change the process at all? I mean, other states do it a little differently, as I understand it.
Well, and certainly I suppose I could, look at these particular investigations, the problems that have been posed by them when you're talking about your governor, right? Whether they're Republican or Democrat, you're going to have the nuances of politics in the background. And that might be something where, you talk to the legislature about how we can improve the process in those types of circumstances. In general, our John Doe statutes are good. I mean, they allow, citizens to make complaints, to have investigations and to have oversight. But I think this case has sort of been unusual. I think we can all agree on that, both in terms of its inception, how it's evolved, and then, of course, all of the players that have been involved.
Judge Easterbrook did say that he thinks it's unconstitutional that John Does don't allow those who've gone before the John Doe judge to talk or to speak publicly about that. You've discussed unconstitutionality. Would that be a concern at all about the John Doe statute?
Yeah, and how did Judge Easterbrook phrase? He just said the fact that they can't speak.
They were discussing the thing, and he said that he saw a potential First Amendment.
And there could be. I mean, I would have to look at the context and certainly the facts of the case, and I assume then there was also an order from the court telling witnesses that they could not speak about the case publicly. And I assume that was for the purposes of maintaining the integrity of the process. But, sure, anytime that you're curtailing a citizen's, First Amendment right to speak, it's definitely concerning.
Last night, you had indicated environmental issues came up several times, and you had indicated that the DNR in several instances has not referred cases to the Attorney General's office. And I'm wondering how you know that, if you can identify cases that you're speaking about.
Sure. Sure. So we had a case in Jefferson County where after the fact a citizen, was upset about the handling of some DNR violations involving some human waste, a lot actually, of human waste that was dispelled, onto the ground, and ultimately had long-term ramifications. And that occurred both, ironically enough, in Jefferson and Waukesha counties with the same company, and only after the fact did we become aware, of the significance, the gravity. And the issue there was that, you have DNR officials issuing the citations, working with the violators, which they do, which is appropriate. But given the magnitude of the sewage that was dumped, certainly was of concern to the homeowners, who were worried about their groundwater being safe. And certainly of concern, I think, to citizens, and as well, I think, probably to both Brad Schimmel and myself, because, the tickets are issued. People generally, when you have DNR citations, if they want, they can simply be defaulted on the ticket. So the district attorney's offices don't have physical files relating to reports or what the actual incident involved unless there's actual litigation. And in that case, I think the press was actually calling, for answers about why that case hadn't been referred to the Department of Justice.
I believe that case should have been referred.
Now, to be fair, I know what I've read in the papers.
Yeah.
I know, what the minimal amount in terms of the citations that were issued in my county. But it seems to me that was an extremely large amount of human sewage that actually did have the potential to impact numerous, dozens, I think, of homeowners, subsequently. So that is a case that at least I would say we should have looked at whether that should have been referred to DOJ. It's been called one of the worst cases.
Is there more that you can do as AG, or you could do as AG, to get those cases referred to your office?
I think it's a matter of sitting down with the folks at the Department of Natural Resources and saying, what types of violations are you seeing? What is handled, through your department by virtue of citations? What types of violations are going to DOJ? And how can we improve not just on the communication, but on the coordination? What we want to see with environmental violations and with, our criminal justice system or justice system in general is people who have contact with the system fix the behavior, right? So if you have a smaller violator who's had some sort of environmental violation and they fix it, great. If they don't and you've got these chronic violators, or if you have violations that are of such a large magnitude that have such a direct impact on homeowners and groundwater, et cetera, then those are the cases that I would want to emphasize that ought to at least be coming to the Department of Justice for review to determine if they're appropriate for Department of Justice involvement.
Do you think this is a politicization of the DNR? What's the reason that they're not being sent over?
Yeah, and see, I don't know that because I'm not in the Attorney General's office now, but I think that's why you sit down with people, right? And you say, look, have there been cases that have been referred and not handled and maybe you're not sending them over for that reason? Or is it just a matter of, we're addressing them because we're the ones having contact, whether it's a corporation or an individual. So I think, it'd be ill-advised for me to try to guess, what's going on there. But, I think certainly there needs to be more communication, more coordination, and more demonstration, from the Attorney General's office that these types of violations, especially when you're talking about people who are chronically violating or people who are having such large violations with such an ability to have, tremendous impact on so many homeowners, that's going to be a priority.
Would you like to bring back the public intervener position?
That was talked about a lot in the primary. I like the idea of what a public intervener stands for, meaning an ability for citizens to have access to the courts. But I don't think we need to call it the public intervener to have that. We've got an environmental protection unit, right? We've got the tools, we've got the attorneys, we've got the DNR officials who can help coordinate with those environmental protections. So I know that we've had a lot in the primary and in this general election about plans.
Is it just because it's a lightning rod? I mean, it has become. Republicans come in and it's removed. Democrats come in,
Sure.
it's reinstated.
I think the reality is that it's unlikely that it would be reinstated, quite frankly. And so I think the smartest thing to do would be to just make sure that we've got enough resources in that unit, again, coordinating with, the DNR officials and even talking to, corporations about, their contact with the DNR, good, bad, or otherwise. I think anytime you can get all the appropriate players sitting at the table to have these good discussions, everybody wins.
You indicated yesterday that there were multiple instances where the DNR had not referred cases to justice, and you just made reference to one, and I want to be clear about that. That's the one that came into news reports a few months ago, not one several years ago, right?
This was the hair environmental.
You're speaking about hair environmental.
Case.
Okay.
Right.
So besides the hair environmental case, are there other cases that have not been referred, to your knowledge,
Right.
that to justice that should have been?
Not specific cases. It's something, as I've traveled around the state, where you do hear a lot of folks talking about that there are DNR violations that are not being sent to the Department of Justice. But I think we definitely have to look at the number of cases, the specifics, to say whether it would have been appropriate or not. I think it's not fair to say, that the DNR hasn't referred the cases that should have gone to the Department of Justice without looking at what those cases were.
You kind of said that last night.
I said what?
I think you kind of said that last night, that there were multiple cases that have been referred to.
Well, the hair case had 5 citations, and so there were 3 that were in Waukesha County and 2 that were in Jefferson County, and that's the case that I have the most direct knowledge about. Yeah.
On a topic that I think everyone in Wisconsin probably has their own opinion on, you've said you're not in favor of making a first-time drunken driving offense a felony. Why not? And what do you know that 49 other states don't know?
And it's not making it a felony, it's actually criminalizing it, and that's actually an area where Brad Schimmel and I agree. And here's why. Intuitively, it sounds good, right? There's 49 other states who are criminalized, but you've got to define what you mean by criminalized. Minnesota and Illinois, for example, adjacent states here, criminalize first offense OWIs. But in those cases, most of the offenders don't spend any time in jail. They have an ability with counseling and good behavior and not reoffending to have that conviction come off of their record. And so in some instances, then if you look at Wisconsin's OWIs, our conviction stays on your record for lifetime, going back all the way to 1989. We have, tough laws in the sense that it stays on your record. There's a hefty fine, there's required treatment, there's driver's license revocation. And the reality is this, I've prosecuted people who have killed their best friends. I prosecuted a young woman, I believe she was 19 years old, who killed her best friend. And she's in prison, drunk driving. She's in prison, her best friend is still deceased, and she's gonna have to live with that for the rest of her life. The reality is that we don't have the data to show that by criminalizing a first offense drunk driving, it's actually going to deter people from getting behind the wheel. We know that an intoxicated or an impaired driver, in the back of their head, they know I could kill myself, but they still drive. I could kill my passenger, they still drive. I could kill an innocent motorist on the roadway, and I could spend decades in prison, but they still get behind the wheel. And so what I've said is that if there was data to show that criminalizing it would actually deter people from getting behind the wheel, then that is something I would certainly take a hard look at. But right now, we don't have that data. And so what I've also talked about that I do know, because we do have the data, would be that we've got to get tougher on these repeat drunk drivers, people who don't learn from their contact with the justice system. They go out and they chronically get behind the wheel. Right now, fourth-time offense drunk driving, as little as 60 days in jail in Wisconsin. That's wholly inadequate. So we need to start looking at these mandatory minimums, which are the absolute minimum that someone spends in jail, and start making those significantly higher, because these are people who have had contact with the system, haven't learned from the behavior, and then they're reoffending.
And yet, first-time offenders, studies show, are not really first-time offenders. They've often driven drunk
Sure.
multiple times before they've
Absolutely.
been caught.
And that's part of the societal problem, is that societally, it's sort of accepted. And people are playing Russian roulette every time they get behind the wheel. And so, something that we know is that when drivers get behind the wheel, and this is maybe why they do it, they don't expect to get caught. And so, increased law enforcement presence, having grants that are in place that can allow, troopers, for example, to have, more involvement, more contact with motorists, particularly after bar time, and talking to our kids. We gotta talk to our kids about drinking and driving, so that culturally, societally, we start working on the acceptance of it. This past year, I went to my high school in Jefferson and talked to the kids the week of prom about the dangers of drinking and driving. So we know there's a lot more that we can do. We know that the person who gets behind the wheel on their first drunk driving offense for which they're caught, or their fifth, pose the same danger to the motorists on the roadway. My concern has been about whether criminalizing would actually deter them or prevent them from getting behind the wheel in the first place, for all the reasons you've raised as well.
There are also second first offenses, which you've discussed, the Graham Zielinski case in particular. I haven't heard, were you involved in the decision on how to charge that case or not?
No.
You were not?
No.
Why did you choose to remain out of the case?
Right. No, that was a case, well, first of all, I only handle felony drunk drivings, but that was a case that I actually caught wind of it when some of the press were coming to the courthouse. Didn't know Graham Zielinski, honestly didn't really understand why the press was involved, and then once I realized who he was, my only involvement was to make sure that the attorney prosecuting that actually had a hearing in public, on the record, where Mr. Zielinski actually took the stand and talked about the fact, this was relating to his challenge about the constitutionality of his plea. In the early 90s, I believe it was, out of state, he was convicted. He didn't have an attorney. And he testified, apparently, that he didn't know what an attorney would do, what the state had to prove. And the nice thing about having that in the public was that the judge got to weigh his credibility to determine whether that was a credible argument. And so ultimately, the state was not able to pursue that as a third offense because he not only didn't have an attorney, and the court found after hearing his testimony that that was not a constitutionally valid plea, but also because we couldn't produce the necessary documentation from that other state about the actual existence of the conviction. So it did become a second first, and that's something that we've talked about, that's a loophole that we should look into, because when you have someone who goes more than 10 years between their offenses, you don't get to go back lifetime, so that at least it would have been a second offense, right? Even if you throw out that middle one, it would have been a second offense, and it would have been criminal.
So how do you want to fix that exactly?
Well, the legislature, I know this has come up before, certainly it would be an easy fix, right? To just allow someone to go back lifetime, so that someone in that situation, you know, you have a violation, and I don't know what the exact year was that Mr. Zielinski had, and a prior from the early 90s, it would still be a second offense. It's easy enough to write.
How do you feel about the drunk driving courts and the drug courts that have been?
I think they're a really good use of our resources for a number of reasons. The first is that for every dollar we invest, we save $1.91. So they're a good investment in terms of ultimate return on our investment. But I like them particularly for drug cases and for alcohol cases because these are a lot of the things that drive crime generally. You know, much of our crimes are committed because people are under the influence of alcohol or drugs, and they directly impact public safety. In Jefferson County, we're really fortunate this past year to be able to receive an alcohol grant, and we've created an OWI court that's targeting high-risk offenders, and these are offenders. They're third through sixth technically. I don't see a sixth offender, quite frankly, ever really participating in our court. But you know, you're looking at repeat offenders who have had touches with the criminal justice system. They've gone to jail. Some of them have gone to jail maybe for 6 months or longer, and they're back. And so this is a great opportunity for us to safely supervise them in the community because they're wearing what we call a scram bracelet. It's a monitor that detects whether they're drinking. When that comes off, they're still subject to submitting preliminary breath tests. They're required to go to counseling. They have to undergo participation in Alcoholics Anonymous, and they're subject to the court. They meet with a case manager. They also meet with the court. They staff, so if there are violations, they can be dealt with swiftly. Ultimately, when they complete our court after about 12 months typically, and sometimes longer if the offender is having a hard time, you know, with their sobriety or having issues along the way, they come out on probation. So we've got coordination with probation, the courts, the district attorney's office, and their attorney, so that when they come off of the alcohol court, they still have time on probation, so they're still supervised in the community. And I think that's their best tool in terms of actually living a sober lifestyle and not posing a risk to the public. So I think we can do more to help fund and support drug courts, you know, alcohol courts, and these diversion programs.
On that issue, one more question. It's not necessarily a role for the AG, but how do you feel about sobriety checkpoints and interlock devices on cars?
Now, let me start with the latter one because
Sure.
the ignition interlock devices, they sound good and they are good if they actually work. And the problem we have is that many times drunk drivers, even if they're on supervision or you know have been recently caught, drive someone else's vehicle. So I like ignition interlock devices. The difficulty has been with enforcement on making sure that drivers actually have them in the car and that they're not driving. I mean, we see operating after revocation cases all the time where they're still revoked from their previous OWI and they're driving, or they might even still be on probation and they're driving. And so, you know, the ignition interlock devices are a great tool, but we really have an issue with enforcement. In terms of the sobriety checkpoints, again, I as a citizen on the roadway, as a prosecutor, I certainly like the idea of people, like you said, maybe not knowing if they're going to be pulled over, because the average drunk driver does drive many times. I think at one point the Highway Transportation Safety Board, you know, had something somewhere, you know, about 50 times before an offender is stopped. You know, but then from personal citizen standpoint, I think a lot of your drivers who are sober, who are following the law, you know, find that to be, you know, something that is intrusive. But certainly in terms of having them from a public safety standpoint, I think that's something that definitely would deter people who think that they're going to get away with driving intoxicated if they know that there's more people out there and that they could be stopped.
Would you mind grading our last two attorney generals, saying how you think they did and explaining why? J.B. Van Hollen and Peg Lautenschlager. A, B, C, D.
On everything that they've done?
Just in general. I mean, J.B. has been in office 8 years. It seemed that you had some impressions during the debate yesterday about some of the things he did. Would you mind just saying, you know, overall, how you would grade him and how you would have graded Peg's performance as well.
Yeah, I think it's difficult to give an overall grade, much like, a high school student is going to get an overall grade for all of their classes. Are there areas where J.B. Van Hollen has done a really good job? Yes. He's done a great job on talking about the heroin and opiate epidemic. He's, got the fly effect in terms of public awareness and public information. I think he's done a good job on talking about human trafficking and internet crimes against children. On the flip side, we saw with internet crimes against children that tips were sitting on a desk. They weren't being timely processed. Now we know, again, in fairness, that these tips have exploded. We know that we haven't been able to keep pace, but we also know that that is a misstep that has caused our children to fall through the cracks. I think we can do more in Department of Justice in terms of environmental protection, in terms of consumer protection, and in terms of having confidence in our elected officials. So I'm reluctant to give a grade on the entire tenure of Attorney General Van Hollen, first and foremost because I don't, there's a lot of things that he has done that I'm probably not aware of. And so I don't think it would be fair to grade him in that respect, but I think I've been very fair in my discussions about things that I have, disagreed with, things that we can improve on. In the heroin epidemic, as I said, he's done a good job, but I also think there are ways that we can bring the information to the public as opposed to having the public come and access it, like with the heroin summit that I put on in Jefferson County with our heroin task force, to put a human face on heroin and the opiate epidemic, because I think a lot of people have a preconceived notion of what a heroin addict looked like. In terms of Peg, I think she did a lot of good when we talk about some of the areas that I have concerns on, which are consumer protection and environmental protection. But again, if I go back to her tenure, I first was elected district attorney in 2008, and quite frankly, was more involved in things in my community, in public protection in my community, and the things that were going on in my private practice. So it'd be very difficult for me to give her an overall grade, because I, quite frankly, in terms of the things that she has done, or if she had things that she hadn't done, that would be difficult for me to do.
How would you grade your opponent? He's a neighboring DA.
In terms of what, though? In
His
terms of
overall tenure in that office.
Yeah, I would give Brad a good grade, because he has been, much like me, a frontline prosecutor. We've faced the same challenges, whether it's, sexual predators, heroin epidemic, doing more with less. We've all been hindered by the fact that, we have these very complicated cases, and we've got turnover, with prosecutors, and we're trying to, fight to get our prosecutors, pay progression, and to get more attorneys to help us with our caseload. So, in terms of being a district attorney, like you said, we work together a lot. We've done special prosecutions for each other. We've worked with one another. We've given each other advice, and as a colleague, I would give him a very good grade, because we have worked together for a long time.
He's made a big deal out of the fact that he's received more law enforcement endorsements than you have. I don't generally care about about endorsements, but why is that he's received so many more?
Well, and I don't keep tally on the numbers. We've got law enforcement endorsements throughout the state. We've got, former assistant United States attorneys. We've got, former attorney general. We've got former governors. And I think part of it was, quite frankly, he got into the race much, much sooner. I was the last, even in terms of the Democrats, to get into the race. But, we were focused on getting through a primary. And that was my primary focus, was, quite frankly, connecting with enough voters to win, raising the money necessary to come through the primary. And we did a really good job. We won every single county. We earned 52% of the vote. And so, if he's got more endorsements, that's okay. This race isn't, like you said, isn't going to come down to the number of endorsements. It's going to come down to, who's going to best represent our citizens. And something I will say, being the Democrat in a Republican county, I think that is something that does distinguish me from my opponent, in that I have a demonstrated record. My life every day is working with Republicans, so people not from my party, and still being able to get the job done. I was the first Democratic district attorney elected in Jefferson County in 70 years. Part of my success in being elected in 2008, despite the fact that I was a Democrat, was my ability to earn support from law enforcement. They were a very important role in my success in 2008, and I think I earned their trust, and then I kept their trust in 2012 because I was reelected without an opponent. And so, my ability, my demonstrated ability to keep the politics out of that office, I think speaks for itself, because I wasn't handpicked by my party. I actually won, my spot, through a tough three-way primary, and it was the voters, it was the people, who chose me.
Was there someone who encouraged you to run, like Emily's List or any other group that encouraged you to run?
They were. My husband was the first one. When JB announced that he wasn't seeking another term, a lot of us in law enforcement thought, "Ooh, this is an interesting opportunity. That you don't, have an incumbent who's going to be in the office." And so I thought about it right away, but I think my husband was probably the biggest cheerleader on that. But yes, I was approached by both people in the state and outside of the state, and Emily's List was one of the organizations who came to me and encouraged me to run. But ultimately, the decision was mine to make, and I'm really pleased that we've had this journey for the last several months.
So how have you worked with Republicans while you've been Jefferson County DA?
Yeah,
What are some examples?
so we've, one of the things the first thing I did when I came into the office, came in, looked at the budget. We had a $750,000 budget, and I wanted to look at how we could save money. And I saw that we had a lot of money in our process service. So when you're serving subpoenas for court and for hearings, and I realized we could cut quite a bit of money there by not issuing subpoenas quite so quickly. But my sheriff and I, my Republican sheriff and I, partnered to save our taxpayers by utilizing my own cost savings and working with my Republican sheriff for him to serve the subpoenas, so that he makes money, I save money versus having a private process server serve. We've saved over $250,000, which I think in my first year was something like $81,000 of that $750,000 budget. I was able to save that money for my taxpayers. And so that's a good example of where, politics, when we're talking about public protection, partisan politics has no place in the discussion. If I had just dug in my heels, or if my sheriff had just dug in his heels and said, well, I'm not going to work with you because you're a Democrat, or I'm not going to come to you about this issue because you're Republican, I think we would have done a real disservice to our citizens. So I'm very proud of that ability for us to work together. We also work together just on issues of general public protection. Figuring out how we can improve the processes, whether it's how files are referred to my office. As I said, a lot of my sheriffs and law enforcement folks are more Republican leaning, and one of the first things I did when it came to referrals that come in was we call them no prosecution decisions. So when an attorney decides that they're not going to prosecute a file, that there's a memo that's drafted to law enforcement, and it gives law enforcement an opportunity to talk to that prosecutor before that decision is final, so that if they believe that a case, that the attorney is inclined not to charge, they believe very strongly that it should be charged and want to sort of plead their case to the attorney, that they can do so. And that's really improved the working relationship and the respect that law enforcement has, and the working relationship that we have with our office.
So there's a sort of a history in the state going back over the last few years of when the opposite party is in the AG's office. That doesn't always work real well. Governor Doyle, AG Doyle, and Governor Thompson were not exactly best friends. So to continue with what you were talking about, you may well have to deal with a Republican administration. So how do you do that? How does that manifest itself?
I think I do it the same way I've been doing it, which is to have the partisan politics stop at my door. Because as district attorney in a Republican county, if I interject politics into my office, I'm probably out of a job in 2012, because it would not probably have been that difficult to find Republican candidates to run against me. And so I would approach it the same way. Look, the Attorney General's office and the Governor's office are separate branches. They are a good check and balance on one another, but to the extent that they can work together to do better for our citizens, I think that's incumbent on both people to do that, whether it's a Republican or a Democrat. in the office, shouldn't matter. Could it be potentially more difficult or more contentious, as you've indicated? Sure. But I'm willing to sit down with anyone, regardless of their political affiliation, and talk about issues. And something that struck me, what I was thinking about the other day, was that I had a law school professor, and I can't remember what subject it was, but they said the essence of compromise is when the two parties sit down to a table and neither one walks away happy. And that's okay, because I think there is a lot more common ground than we know. And maybe having someone with my demonstrated record of actually being able to work with Republicans, to do the job, to keep the politics out, maybe that will instill some confidence if it ends up being Governor Walker, that I can actually do that, because it's something that I've done. It's something that's part of my record of working with Republicans and Democrats alike, to protect our citizens.
There's very little evidence of that today in Madison. So, I mean, can you really take the template of Jefferson County and apply it to Madison when you have, if indeed you have a Republican Assembly and Senate and a Republican governor?
I think I can, and you know what, if it doesn't work, it's not going to be for lack of effort on my part. And let me give you an example. When I first was elected, Representative Andy Jorgensen was my state rep. And so I would frequently contact Andy, and I would tell him about loopholes in the laws, or laws that I thought should be written, or cases where a law maybe was having an unintended effect. Representative Joe Clayfish is now my representative, and now I write him. And so when we had what I viewed to be a loophole in our 7th and 8th and 9th offense drunk drivings that potentially allowed judges to not order any mandatory minimum, I said, we've got to fix this. Or another example is I wrote a statute for him. They're not in session, but I wrote a statute that would make it a felony for any inmate to bring any sort of controlled substance into the jail without a valid prescription. So right now they can bring in cocaine, they can bring in marijuana, and it's a misdemeanor. You're in the jail. You're out on Huber. That's a privilege. And so from my perspective, that was another tool that law enforcement needed to deal with, because you're not just talking about someone bringing it into the jail, they're probably using it. Now, if you have evidence of sharing, that's already a felony. But the point was, I have that record of saying, I don't care what party you belong to. If there is a problem, if there's an issue that needs fixing, I'm willing to sit down and talk to you about what we need to do to improve this. And to me, that's the essence of our elected process, which is to be able to work with people across the aisle to focus on public protection. And partisanship and partisan politics has no place in that. I mean, I'm not naive. I know that it's not going to be as easy as Sue Happ being Attorney General and I'm going to fix all of the issues between the Republicans and the Democrats. But I'm going to have the independence, and I'm going to have the drive and the willingness to start calling people out on the carpet if they're not willing to work together on a particular issue, and it makes sense for the state of Wisconsin, it makes sense to make our communities safer. I'm going to do that, and I'll give you an example. Background checks. Why haven't we passed that? It's not a partisan issue.
Firearms you're talking
Yeah,
about.
background checks, universal background checks. This is not a Republican issue. It's not a Democratic issue. It's in fact favored by the majority of Wisconsin citizens and even a lot of the NRA members. But we haven't been able to get that done. Why not? And so I can go to people and I can say, look, I'm not going to take away your guns. I believe in the Second Amendment. I have a carry concealed permit. I grew up hunting. But I still think background checks are a good idea because they're about keeping guns out of the hands of people who shouldn't have them. Not about restricting access to guns by law-abiding citizens, but we want our felons, our people who are subject to domestic abuse or protection orders, and our domestic abusers not to have access to weapons. And the greatest example that I can give is the Azana Spa shooting. Here's a man who's got a restraining order. He legally cannot have a gun, yet he's able to go out on the internet and purchase one because half of Wisconsin's gun sales are done with no background check whatsoever because they're done by either sitting across the table type transactions or these internet transactions. And the victim there were three, but the estranged wife, Azina, her brother is an NRA member and doesn't suppose restrictions on guns in general, but says this is something that we need to get done. And he correctly said, it's not about gun control, it's about gun responsibility. And so that would be an example where I think the Attorney General could in an appropriate fashion utilize that bully pulpit to say, legislature, why haven't we gotten this done? Because it's not a Republican or a Democratic issue to talk about how our communities are safer, how our kids are safer by implementing common sense measures to make our cities and counties safer.
Having said all that about bipartisanship, you still have to get elected first.
I do.
And many people are going to view this race strictly through party labels. How strong is your Democratic Party affiliation, and what would you say to Democrats? Why should they be excited about voting for you?
You know, the Democrats, my Democrats support me and they like me, but they also know that I'm not a traditional Democrat. And I think maybe that's part of the appeal, right? Because if all I do is pander to my base, I'm leaving out half of our citizens. And so, you know, there are like the areas of carry, you know, me having a carry conceal permit might make your traditional Democrat a little uneasy. But then they can see, you know, I talked about why I have a carry conceal, that I'm a member of law enforcement, and that I'm, you know, traveling at dark after, you know, having, you know, prosecuted a lot of really bad people. I think if if people understand who Susan Happ really is, they're not concerned about you know, my beliefs or my Democratic roots. But on the other hand, I think the Republicans and the moderates can trust that, you know, I'm not going to be out there with this strict, you know, partisan agenda because of where I come from. I can't get elected in Jefferson County by simply earning votes from Democrats. I have to earn votes from independents and Republicans. And in order to be reelected in 2012, I had to keep that trust about keeping politics out of my office. So, you know, it's going to be an interesting race, but you know, I don't intend, and from the very beginning when we had the primary, to simply talk about representing Democrats or appealing to Democrats. I need to represent everyone, and my record shows that I've done that as district attorney without a political or partisan agenda, and that's what I'm going to do as Attorney General.
We have time for one last question.
Well, I
Would
wanted
like
to
it.
ask,
Ernie.
By some measures, Wisconsin has one of the worst rates in the country on African-American male incarceration. Is that something you're concerned about? Is there something your office can do as Attorney General?
Well, the first
address
question,
that?
absolutely. Of course I'm concerned about it. It's shameful. And again, you know, this isn't any sort of a partisan issue. You know, we don't want to be known as being the best for the worst, meaning these incarceration rates. And so we know that we have to do more. And I think first and foremost, what the Department of Justice can do, what the Attorney General can do, is start talking about it, acknowledge that it's an issue, and then be willing to look at, you know, how we got here. You know, are there certain types of cases in certain counties that are treated differently? You know, is the same offense, like maybe it's a drug offense, maybe it's, you know, a pot case, that's treated differently in Milwaukee County versus Waukesha versus Jefferson County, and is that leading to these disparities? And we have to acknowledge that law enforcement, both in terms of officers having contact with defendants and those of us who are prosecuting, have a tremendous amount of discretion. And so from the point of contact that law enforcement has with an individual, he or she can determine, do I cite? Do I arrest? Do I refer misdemeanor charges? Do I refer felony charges? And then we as attorneys, prosecutors say, you know, do I send them into a diversion program? Do I give them an ability to earn a dismissal? Do I charge the felony misdemeanor? So we're going to need a multifaceted, collaborative approach to address this issue, and I think the Department of Justice has a wonderful opportunity to be a key player at the table.
Susan Happ, thanks for being with us on 4th and State. It's been a pleasure having you. I'd like to remind our viewers that we'll be meeting with Governor Scott Walker tomorrow. That's at 12:30. Come back for that. His opponent, Democratic challenger Mary Burke, is at 10:15 on Wednesday. And then Susan Happ's challenger for Attorney General, Brad Schimmel, the district attorney in Waukesha County, will be with us at 11 a.m. on Thursday. You can also find all of these interviews at our YouTube channel for the Journal Sentinel and at JSOnline. Thanks for joining us.